crisis in the future, because it ensures that you already appointed the necessary beneficiaries for each of your assets and asset classes. So also, it also prevents external manipulations from even family members or even third parties. It helps you ensure that nobody has a say over your estate, has a say over your assets, even when you're not there. Meaning that even when you're not alive, even when you're incapacitated, your estate plan can speak loudly for you, speak to the point of ensuring that your assets, your estate is properly distributed amongst your beneficiaries. I hope I'm still very, very clear and loud. Please call my attention if nobody can hear me, please.
Yes, I
So,
can hear you. Or I can hear you.
all right, that's fine. So your estate plan also helps you to ensure that the lifestyle of your spouse, your children remain the same in your absence. So for example, you know that every year you always like to go for summer vacations with your family members, or you and your family members like to just go for vacations or family journeys together and all of that. But of course, you know that at the point where you might not be alive, there might not be funds enough to actually maintain this lifestyle. Your estate plan, there might be instructions in your estate plan to say that, okay, I want a situation where every year during this point in time, I want a situation where a particular amount of money is given to maybe my children, my first son, to ensure that he and his siblings have a wonderful vacation, a wonderful summer vacation. It could be a yearly thing. It could be it just speaks to the instructions you're given. I'm sure a lot of people don't even know that your estate plan also allows you give instructions for your funeral arrangement. So I would say that in my little experience as a truck advisor, I have seen a lot of set laws. I'll get to the definition of all these terms I'm using as we go on this journey. We see set laws, you see testators that would say that at my demise, I would like to be buried at home with Korean vaults. I would like to be buried with a black casket. I would like to be buried in a very, very loud manner. I would like my body to be taken to the village. I would like my body to be this, to be that. So basically, I'm trying to say in your estate plan, you can also include instructions that that cater to how you are buried, how your funeral arrangements are made. Also, the last importance here is, of course, there are a lot of other importances. I'm sure you know that. Yeah, the last one I have here is it allows you to facilitate the continuity of charitable deeds important to your legacy. So basically, in your estate plan, too, you can also include how you want maybe a charity organization or some sort of legacy that you already have started while you're alive to continue. So basically, you give instructions in any of your estate plan to say, oh, even at my demise, I want a situation where every month you send so money to this orphanage, you send so money to this community of students, you send this to this group of people, you send it to my church, you send it to my mosque. You ensure that during the fasting period, during Ramadan or something, you ensure that, oh, I want a situation where by my name, every year, even in my demise, I want a situation where everybody is fed properly when they want to break their fast. You say, okay, at every anniversary of the church, I want a situation where you buy the church whatever they need annually. So basically, estate plan allows you to put your house in order and also gives you rest of mind. I know you might not be alive, but of course, it allows you to have peace of mind wherever you be. So I have decided to actually streamline the estate planning tools we're talking about today to this five, because at Meristem Trustees, we are heavy on these five estate planning tools. Of course, I know when people say trust, people think trust is just for um, it's just an estate planning tool. But of course, trust is a very, very wide aspect of, of even the financial services. So I have limited myself to this five and I'm breaking them down one by one. We have the deed of gift, we have the nominated funds, we have special purpose vehicles, SPVs, we have wills, and we have trusts. So let's dive into what a deed of gift is. A deed of gifts is used for the voluntary transfer of property from one party, the donor, to another party, the donee, without consideration. Without consideration means without any form of payment. So basically means that me, for example, can say, okay, um, I want to gift maybe my car, my three cars to my three siblings, for example. I will just, if I know that, okay, just by way of gift, I don't want to pay any sort of estate taxes or any of that, I could just say, okay, I would get a lawyer or get a trustee like us, or a lawyer like me, and case maybe, to just draft me a deed of gift that specifically says, okay, at so point in time, maybe at my demise, I want this car, this red Toyota Corolla 2028 or 2008 or 2018 model to be given to my daughter. For example, let me say her name is Tayo Ayegusi, for example. So basically, a deed of gifts allows you to transfer your assets without any form of consideration. Consideration meaning payments or any form of valuable exchange. That's what consideration means in this context. So a deed of gift can be used for tangible items. It can include vehicles, jewelries, furnitures, landed properties, even houses too. So the features of a deed of gift includes no consideration, like I've emphasized earlier. No consideration means you're not paying any form of money, you're not making any form of payment for that gift. Also, the donor's intent and donor's acceptance is very, very key in the deed of gift. Donor's intent in the sense that the donor needs to explicitly state that, okay, I actually intend to give this house to my son. When you say this house now, I will go for that. That's where property details comes in. When you say this house now, you don't just say, I want to give this my house to my son. You have to give proper details of the asset or of the estate you plan to transfer trading or give. So I mean, when you want to do sort of when you want to use an estate plan such as a deal or gift, I mean that you explicitly state that my four-bedroom duplex located should be given to my. Of course, you might even want to even include the survey plan number, the this number, and all of that to ensure that there's no form of dispute later in future. Because of course, if you just say I want to give this my house to my son, what if you have two houses? Which of the houses apply? What if at the end of the day, the house is, what if at the end of the day, there are other people that want to actually lay claims to this house? How would they know, okay, this is the exact house you're talking about? Also, the donor's acceptance also means that in a deed of gift, there needs to be an explicit arrangement that allows the donee actually accept this gift, meaning that actually this deed of gift needs to be handed over to the donee because that is also one of the reasons and one of the things that makes it very, very, very valid. Because if you don't draft a deed of gift and you keep it in your house, first of all, the donor doesn't even know that you transferred anything to them. And then, of course, that means the donor hasn't even accepted such gift, meaning that it's not valid, it can still be contested. So basically, it means that the donor must also accept that gift. I have spoken to the property details and clear ownership right. When I say clear ownership rights, I mean in the deed of gift, it also needs to explicitly say that you've transferred every legal ownership that you have in that property to the next person, which is the donee. So it states that okay, the donee is not a new owner of such assets, whatever kind of asset it is. And of course, we also have witnesses. I don't know if you've seen documents where, of course, when the executor actually signs off, you know, certificate where they say in witness of. That in witness of is actually a very good clause for legal document that allows for the validity to ensure that okay, this person didn't just make this information, this person wasn't coerced or under duress when we're signing such document. It just shows that okay, there were witnesses present when such person was executing or agreeing to actually give out this asset or this particular estate that they have. Also registration. Registration just allows the law or the government to recognize that okay, this property no longer belongs to this person. So I'm trying to say that, for example, you want to dash your brother a land and you already prepared the deed of gift, you've even given the donee his own copy of the deed of gift. It doesn't just end there because at the end of the day, a situation might arise and then the law or the court or the government doesn't even recognize that such transfer had happened at some point in time. So I mean that you need to register such deed of gift with maybe the land registry, as the case may be. You just need to register it with some sort of registry. For this case, a land or a building would be the land registry, for example. So the deed of gift is actually a way of actually gifting out. Of course, it doesn't speak to a lot of assets. It is specific. You say, okay, I have this jewelry, this gold jewelry, what's maybe it's 25 carats and all of that. I want to give it to my daughter. She needs to wear for her wedding and all of that. You need to be very specific when you're actually drafting the deed of gift. But of course, a lot of people don't use deed of gifts nowadays because of the intricacies and the complications that might arise with that. But some people will tell you that they don't believe the deed of gift actually carries the power that it should. But a deed of gift is actually a very, very solid estate planning tool, and it is actually what's using often too. So let me go to the next um, tool that I mentioned. This is nominated funds. Nominated funds, as you can see on my screen, actually speaks to funds. That's why the name is nominated funds. And it doesn't speak to your car, it doesn't speak to your house, it doesn't speak to your jewelry. It speaks to your near cash assets. It speaks to your funds, your proceed of investments. So basically, it is just a specific directive made by a person, the nominator to a trustee, that upon their death or incapacitation, their funds should be paid to a particular individual. So the reason why it is particular to a trustee or particular to your asset manager is because a lot of us, for example, have investment with a lot of asset managers. We have investment, we have shares with a lot of stockbrokers and all of that. And then you're just bothered that okay, when I die, what would happen to this investment? Because nobody might even know about that investment you have because it's not your investment, everybody will know about. So the nominated fund just allows you give a directive to maybe asset managers or the trustees in the case, whatever case it might be, to say, okay, at my demise or my capacitation, I want you to give the returns from this investment or the returns from this investment at maturity to my son, to my brother, to my sister. Whatever it might be, it's just you giving instructions that at the end of the day, this investment, when it matures, or this shares that I have at the point where you want to sell everything off, please let the returns go to my family member or beneficiary. So the features of the nominated fund, I mean, include the following things I've listed. So basically, nominations can only be made in cash or net cash assets. I've explained that earlier. The amount of funds to be allocated must be clearly stated and the beneficiary must be identified. So, like I said, also that's one of the major things, major strengths of an estate plan. An estate plan actually allows you to appoint your beneficiaries. I mean, appoint and indicates that oh, this is my beneficiary. Also, indicates the exact assets that you want to transfer to the first beneficiary. That is one thing you see that goes across all or major of the estate planning tools that we have in modern time. Also, nominations must be in writing and executed by the nominator. Also, it takes effect upon the demise of the nominator. So now it's not a thing of a gift where you're giving the person immediately. A nominated fund is a tool that works for you upon your demise or incapacitation when, of course, you can't make decisions by yourself. But of course, you protected that fund, you protected that investment, so that even when you can't speak or when you're no longer alive to make directions or directives, the trustees or your asset managers already know that, okay, we need to transfer this asset to this person, this beneficiary that we appointed by the nominator. Nominations can only be revoked during the lifetime of the nominator. So it means that the only time you have to change your nominations or your appointments is during your lifetime. Upon your demise, nothing can be done about it because the nominations are only done by the nominator. And at the end of the day, it's only nominated as the final day. Also, it is not subject to probate and estate taxes. When we get to wills, we'll talk more about probate and estate taxes. So let's go to the next one. The next one is a special purpose vehicle. This is one that a lot of people don't even know about. But yeah, a special purpose vehicle involves the incorporation of a private company and entity in which the settlor and intended beneficiaries are shareholders. Simply put, SPVs may be incorporated locally or offshore under offshore trust arrangements when necessary. So let me just make it clear. A special purpose vehicle works hand in hand with trust. So I'm trying to say that a special purpose vehicle in some cases might be set up for a particular purpose of its own. But in most cases, you see SPVs being incorporated because maybe a trust has been set up and then some sort of shares, maybe shares of private companies or even assets need to be transferred to maybe beneficiaries that are still very young or something. So the structure of an SPV goes in way I've highlighted. So basically, the settlor and the appointed beneficiaries are usually shareholders in the incorporated entity, and then the settlor then transfers their portion. I will explain what the settlor is along the way. The settlor then transfers their shares in the SPV to the trustees. Let me give an example. The example will be that, for example, you and your husband probably have houses, a lot of houses, and then of course your children are still quite young. You even also have business. You have a very, very big company, but then you have children that are still maybe minors, and then you're just wondering, okay, what happens to what happens to my assets, what happens to my shares in this company, what happens to this my property if I go on early and there's nobody to actually monitor or all these things to my children. But of course, the children might not be able to handle these things. You can invite a trustee in and say, okay, out of my 100% shares in this organization, I would, of course, now it is not a functional organization like maybe your company itself. Like I said, it involves the incorporation of a private company, a small business. Usually, it is just the trustees or the asset managers will help you in the operation of that with CAC. So it is not as if we are getting involved with your major business. We're just setting up this SPV, that's this entity, to be able to transfer your assets, your shares, your power, your share strength in your capacity to your children at your demise. So basically, you set up this and then you ensure that the trustees are majority shareholders because they are the ones holding this share or this assets for your beneficiaries at the later age. Remember, I said they might most likely be minors or maybe children that you probably want, okay, let them finish their school first before they become shareholders in this company. So it just means that at your demise, the trustees being an entity now, the trustees being a juristic person, of course, the trustees being a juristic person, of course, would hold this asset for you over time. Because of course, we know that unlike human beings, companies don't just die. Companies can die, companies can liquidate. But of course, unlike human beings that will die, and once the individual dies, that's the end. For a company, even if the director dies, even if GMD dies, the company still lives on the GMD or under GMD we are appointed. That's why it's always safe that your trustees are usually juristic persons, not natural persons. Also, the trustee becomes the recognized shareholder and thus the assets come under the trust. I will explain the relationship between SPVs and trust as we move on. So please let's go on to wheels. Okay, let me give you just the little features of the SPV. So SPVs can actually be used to hold family investments. Like I said earlier, you have children that are still minor, and then you just want a situation that okay, at your demise, maybe anything happens all of a sudden. Because we hear cases of of investors, billionaire investors, and all of that, just traveling for business, and their plane crashes. Of course, some of these people might have plans, some might not have plans. But of course, if there's already a plan in place, even if your children are minors, you already know that okay, your trustees already hold these shares, hold these assets in trust for you, in trust for your beneficiaries. I mean, also it helps you it gives you the peace of mind you need that okay, in long term, no matter what happens to me, no matter what happens to my spouse, this asset, this share, this wealth, this asset that I've accumulated can be properly transferred to my beneficiaries. also seamless, it allows for seamless coordination, and it also allows for continuous retention of assets, meaning that you don't need to be bothered that, oh, maybe one of your rivals at the office or your rival or someone that will be dragging something with you will have the power to just buy up all these shares, because of course the trustees are working in your favor, and of course they are holding these assets, these estates for your own beneficiaries, and of course there's nothing that can alter or change your instructions or plans, as the case may be. So now let's go to wills. A will is a written instruction that a will is a written instruction that's signed by the testator. Now, a testator is somebody that writes a will. For example, I'm the testator when I'm the one giving instructions in my will. For the women, it's called the testatrix. So for the men, it's called so it allows. Okay, the will actually directs how your estates are distributed at death. So a will only comes to life at death. That's a simple way to put it. A will only works for you when you are gone. So meaning that any instructions you put in your will can never come to life or until your demise. Not even incapacitation. Even if you get incapacitated for 20 years, whatever is in your will cannot be read up until you are gone for good. So assets must be identified, must be specified and identified, and the beneficiaries clearly identified in the will. I don't know, I'm sure we'll see that there's a consistent pattern in all of the estate planning tools that we mentioned. Beneficiaries need to be clearly identified. So now this will bring me to the differences, because I know a lot of people mix these things up, a next of kin and a beneficiary. I would let you know that a next of kin is just your nearest or closest family member, who may be your bank, your hospital, your asset manager, who call upon any eventuality or in case of any situation that may arise. So basically, it doesn't mean that your next of kin, anytime you go to the bank and say, oh, you want to open an account, yeah, which is your next of kin, or you are filling the form, you say your next of kin, and you're thinking, okay, because you've written your son's name, or you've written your husband's name, upon your demise, the money goes to the person. That's not the case. So the fact that you fill the form and then you've written a next of kin there doesn't mean that you already have an estate plan in place. So because at the end of the day, because there are situations where people die, and then once they die, the monies they have in their bank accounts, the investments they have, just die with those banks or go to those banks by default, because they won't tell your next of kin that, oh, come and claim the money, because as a next of kin you actually don't have the rights to actually claim that money. Yet I would explain when the next of kin can actually claim. The next of kin will be able to claim when an individual dies intestate. Intestate meaning you die without a will. So at that point in time, you have to go to the probate registry to actually apply for the for a letter of administration. But if a person dies with a will in place, all you need to do is go to the probate registry and ask for the grants of probate. The grants of probate is the government power that is bestowed on your beneficiaries or executors to actually share or distribute your asset as you've been instructed. But of course, if you die intestate, that means you don't have a will in place. Pending when maybe your family members, of course, when you die, your family members are going to claim your assets, your wealth, your estate. It's at that point you have to go to the land registry, sorry, to the probate registry, for example, to apply and say, okay, this person died without a will. But of course, we as family members know he has all of this assets. We need the permission of the government to be able to distribute. This is because most of these our assets and all of that are actually subject to some taxes, yeah. So I will explain further when I go down for that. Explain when I get to the features. So basically, like I said, the differences between a next of kin and a beneficiary is the fact that a beneficiary is the person that is actually legally bounded, or let me say legally identified as the recipient of a deceased person's estate. So I mean that until you say, my son, I want to give my son this house, I want to give my daughter this car, I want to give my brother that land, the law doesn't recognize anybody as your beneficiary, not even your next of kin. So why a next of kin will be able to claim in the case of a person dying intestate because the government or the law will think of, okay, who is the nearest person this person has trusted in their lifetime, and of course the next of kin can now come to play. I hope you understand that difference. So the features of a will that I listed here will be, of course, I mentioned that already. It is at the point of demise that a will comes to life. Like I said earlier, a will doesn't even work even when you're incapacitated. So no matter how sick you are, no matter how incapacitated you might be, your will can never speak until you are gone for good. So the content of your will do not remain private. I would explain further why this point is there compared to a trust. So a will is not a private estate planning tool. When we mean private, now, we don't mean before the will is read. So before a will is read, of course, it is private, it is confidential. But upon it being read, I mean, maybe when at your demise, you already they've read like the probate registry, your assets are already started going through the distribution phase and all of that. Anybody can actually go to the probate registry and say, okay, I want to see the will of Chief Ayebusi, for example, now. And then of course, the probate registry is not bound to keep it because it is not a private document. It is a public document and it is accessible to anybody. That's why you see people say stuff like, oh, in Ghana Fireman's will, for example. I'm sure we're all familiar with Ghana Fire. You hear people say, oh, in Ghana Fireman's will, for example, he puts that he wants this, he wants that. And then you begin to wonder, okay, how do they know that Ghana Fireman said this in his will? It is because a will is not a private document once it is read. Also, a will goes through probate, and because it goes through probate, it is subject to estate taxes. Estate taxes are taxes levied upon your estate upon your demise. So it is usually relative depending on jurisdiction. But I wrote 10% because in Lagos State, once your estate exceeds 1 million naira, you are subject to an estate tax of 10%. And I mentioned probate earlier. Probate is where a court is being read and where it is lodged. So basically, the probate stress of a lot of Nigerians, a lot of people will call that stress, but sometimes the probate will take their time to actually analyze that. Okay, because there are a lot of requirements. It's not that you just wake up one day and say, okay, I'm going to the probate registry to tell them, oh, your father died, and then you want them to read his will, you want to collect your will from his will from them. Basically, there are a lot of things that need to be put in place. There are a lot of requirements, there are a lot of requests that the probate registry will ask for. A lot of death certificates, this certificate, that certificate, okay, let us see the passport of the person, let us see this. But I'm giving you this information because as a lawyer, I lodge a lot of views and we know the processes we go through to lodge these views in the probate registry. Anytime we want to lodge a will at probate registry, we usually lodge with the passport photographs of the testator or the testatrix, as the case may be. We lodge with their valid means of identification. We also lodge with there are lots of receipts to payment receipts to show that okay, you went through the normal process of lodging this will. So it's not just you writing a will and thinking, okay, you want to write your will, envelope it and put it under your PO. No, it needs to be properly lodged at the land at the probate registry, meaning that of course when you want to claim, when any of the beneficiaries want to come and claim, they need to actually present, okay, this passport photograph, the address of this person, because of course we write all of that to write the address of the person to show that, okay, this particular person's picture, this person that in this picture actually stayed at number 2 or number 5 Awolowo Drive, that kind of thing. So of course, there are a lot of requirements for you to actually go to the probate to actually claim a will or for a will to be read. So usually, it shouldn't take a long time. But with the way everything is, the way the structures are in Nigeria and all of that, it might actually take a long time. So a lot of people don't like to get involved in wills. Not that a will is not a credible or viable instrument, but a lot of people just say, okay, I don't want my family members to go through that stress. One other thing that actually also turns people off about wills is also that estate tax, that 10%. Imagine that at the end of the day, the government values all your estate to be about 10 billion naira. It means that your family members have to actually pay because This estate tax applies before distribution. So if you cannot pay off those taxes, the government will not release this asset to be distributed. Meaning that if you have an asset worth 10 billion naira, your family members, the beneficiaries, executors need to look for 1 billion naira first. Imagine that your family members are not as liquid, where do you want them to get the 1 billion from? So a lot of people will tell you, oh, I don't want my family members to go through that stress. Like I said, it doesn't mean, it doesn't belittle the strength of the will. Because at the end of the day, in Nigeria, or even in lots of places in the world, yeah, lots of parts of the world, a will is one of the record is one of the most recognized estate planning tool that we have in modern times because it has always been in place and because of the straightforwardness of the information, we are just drafting this, just writing this, and lodging and putting it in the street. It has become very common among a lot of people. So, parties to a will would include the testator, like I explained earlier, the person who makes a will, an executor, that's the person who gets the authority to administer the will. So in your will, it allows you actually appoint executors. Executors, like I already explained, just means a person who has the authority to administer the will basically. So that's the person that actually goes to the court, to the probate registry, and probate court to say, okay, so person passed on. In most cases, there are some people. I remember a case where I was talking to a client of mine, and then the client was telling me that, okay, well, of course, we advise the client to also have a will. And the client said, oh, he doesn't want to have a will because he's currently in a mess. And we're like, oh, what kind of mess? Apparently, his friend appointed him an executor in his will, and his friend never told him about it. So, meaning that in most cases, some executors don't even know the executor of the will. Of course, their only duty is to administer the estate. It's not as if they are many specific things. But of course, in administering the estate, remember the estate tax also apply. So meaning that in all of the running abouts, it's actually the executors that have the most burden when it comes to your will, the administration of your will, the distribution of your will. So it means that if, for example, you don't even inform the executors, if your beneficiaries go to the probate court or the probate registry to say, okay, we want to get our father's will, we want to get our father's last testament, the court will still have to call the executors to say, okay, these are the appointed executors in this will, and they are the ones that can actually take the further steps to actually get the grants of probate. Then your the beneficiaries are persons who benefit from a will in this instance. Or beneficiaries are the ones that benefit from any estate planning tool that you put in place. This will take us to the types of wills. So these type of wills are just subject to what we offer American Trustfund. So I know that I don't know how many young people, I mean below maybe 25 or 20 that we have on this call, but I know a lot of people will say I'm a young person, I just have only 1 million naira in my account. That's the only asset, that's the only thing I have to my name. I don't even have, they'll tell you I only have my car phone, I only have my phone and my phone charger with 1 million naira in my account. That's the only thing I have, and I don't think I need to put in place any estate planning tool. I am just here to let you know that once you are a corporate, or not even corporate, once you're a person that already makes money, once you're a person that already has a retirement savings account, you're a person that already has a pension savings account, you're a person that already makes money from businesses, your account is already loaded with 1 million, 500,000, it doesn't have to be 10 billion, it doesn't have to be 100 million. Once you already have 500,000, you already have 100,000, you already have money that you've worked hard for, it is always good that you put an estate plan in place. Because, like I said earlier, if you die and then you just have 100K in your account, I put it here that your 100K already belongs to the bank, except, of course, you have an estate plan in place that already says, okay, I have so amount of money, or I have this bank account that I run with this bank, and there are some funds in it. I bequeath these funds to my daughter, I bequeath these funds to my friend's child or to my nephew. Yes, that's also something I forgot to mention. Beneficiaries don't necessarily have to be your children. Your father can be your beneficiary. Your uncle, sister, cousin, brother can be your beneficiary. I'm just trying to say a stranger. I mean, when I mean stranger, I mean stranger to your family can be a beneficiary. As far as you've appointed the person that, okay, this is my beneficiary. Like I said earlier, I mentioned charitable causes. Of course, these charity foundations that people and people tend to support even at their demise. Don't necessarily are not necessarily related to them, but because of course they care about these orphans, they care about the less privileged people, they care about these children with special needs, they make them beneficiaries. So I'm just trying to say a beneficiary can even be like I tell people, that woman that sells fish around you, our children might be your beneficiaries as far as they are, like I said, clearly stated. Now, when I mean clearly stated, I don't mean you now say that woman that sells fish, our children are my beneficiaries. No, you need to inquire from the woman, what are your children's names? The names of these children, even their date of birth, sometimes is necessary to be able to ascertain that, okay, this person is the beneficiary they are speaking about in this estate plan. So I mean, a beneficiary can actually cut across your not just your family members, but even outsiders. So the type of wills we offer American trustees is the simple will and the comprehensive will. Like I said, the simple will is the type of will that speaks to your or caters to your cash and near cash assets. When I mean near cash assets now, I mean your shares, I mean your pension funds. Now, I don't even mean investments because, of course, you need to go a step further with your investments and all of that. But if you have cash, you probably have an account, you have multiple accounts with different banks, you have funds in these accounts, you have shares with stockbrokers, with a stockbroking firm, I mean, trading shares on the stock exchange for that CSDL. You also have pension funds. Of course, as we work, we all know that as we are working, we have funds that actually go to our RSAs, that's our retirement savings accounts. So, of course, you want to be beneficiaries to these things, you need to actually put an entity plan in place. So the simple will actually cater to your need. For example, a young person like me now that just has funds and RSAs, I can actually get Maritime Trustees to draft me a simple will that will ensure that even if I die tomorrow, as young as I am, if my mother is still alive, if my father is still alive, my siblings are still alive, my appointed beneficiaries get to enjoy what I have left behind. Then the comprehensive will just speak, as the name states, it speaks to all your assets, comprehensive means everything. It covers everything. You have that Bible that is gold plated, that you bought from maybe Italy, and you worth a lot of millions and all of that. You want to transfer maybe your son to signing documents and all of that included there. You have that very, very expensive couch that was made in France, that is leather, this, leather, that, included in your will. You have this house, you have that house, you have that land, you have this, you have that. Any form of asset at all. I'll let you know that I've actually drafted a will for a client that actually gave instructions on all of his assets to the last thing he had. When I mean last thing, I mean including jerseys. I mean, he bought jerseys, of course. I think he's a fan of sports. So anytime he goes abroad and he goes to watch all of these sports live, he gets original jerseys. And he's not, I'm sure you'll be thinking jersey is just clothes. But this man actually said, this my jerseys, I want them to be given to my brothers. I think he's like maybe the first one, I don't remember now. And then he has a lot of younger brothers that also like sports like him. He wrote it there because I think one of the jerseys, for example, was a Messi jersey, maybe a Barcelona jersey or something, that Messi had actually autographed on. It was like this jersey that was autographed by Messi should be given to my brother. Should be given to my. He made sure that even he has a lot of arts. So he said this art here, this art there. We didn't even know the value up until the drafting of the one. We realized, it actually cost a lot. Even the art he has. I've also seen a client of mine that talked about, I don't know the description of those things, but she said, I think you have to do it pots. I've forgotten what she called the pots now. All this, I don't know, this called them maybe salad pots or something. I don't remember now. But the pots are quite valuable to her, and she included them in her will, saying that at my demise, these stock pots that I have should be handed over to my daughter. This my jewelry should be given to my daughter. My wedding gown, she even included her wedding gown, should be given to my daughter. So basically, an estate plan doesn't just speak to your as far as you find something valuable and you want to transfer, and you want to ensure that whoever gets a hold of this valuable asset of mine is this particular person, an estate plan is necessary for you. So a comprehensive will can actually cover all of these your assets, cover your can cover your what they call it, like I said, your valuables. I mentioned the barrel earlier, maybe it's a gold barrel, a gold jewelry, this, a that. you can always include in your comprehensive will. So the benefits of a will, a testator can tidy up his or her estate before that. So basically, we've been talking about estate plan from the beginning, and then I've been talking about putting your house in order. A will allows you to tidy up and put your house in order before your demise. Assets are distributed in line with the supervision. So basically, no matter where your will goes, as far as your will has gone through the necessary requirements, which is actually lodgement at the public registry, meaning that it has been recognized by law, whatever instructions you have given is what will be followed. So your assets will be distributed in line with your wishes when you're no longer there. A testator can actually also amend a will. So in most cases, you see, you go to the public registry. Let me also explain that. Going to the public registry, you might even find out that a lot of people even have multiple wills. I'll let you know that your most recent will be the one the court or the public registry will uphold as the final will. So I'll say that in a will, there's usually a clause where you say, this my current will is not exactly what I'm saying now, but it just means that your will that you're drafting currently overrides all previous wills that have been drafted by me. So that means it is the most recent will that takes effect upon your demise. But of course, maybe before you die, you want to make an amendment, but you just want to change. Maybe you just realize that, okay, maybe for some reason you put a family member that is elderly in your will, and the family member has now predeceased you. And of course, you know that you already gave them an asset. You know that now that they are dead, the asset might just be lying flat value. You might just want to update your will with a codicil. A codicil is the document that we use to amend a will. To just say, okay, subject to clause so in my will, I direct that this property be given to so person. Now you change the beneficiary because of course now that beneficiary has passed. But of course, if it is a significant change you want to make, maybe you want to change all your beneficiaries or all the assets you already have in place, you've sold them off and you've gotten new assets, you might need to draft a new will. Also, it gives room to select preferred executors who ensure your wishes are carried out. Like I said earlier, the will allows you to appoint executors. American trustees or as an advisor, I would always advise my clients to ensure that their estate plan, their executor, sorry, includes not just individuals. Because like I said, we are human beings and we know how people life is. You could actually appoint an executor today thinking that, oh, I'm sure that I might pass on before these executors. And God is saying, no, these executors will pass on before you. It is always good that you appoint juristic persons. Okay, I'm using juristic since. So now there are two types of persons: there's the natural person and the juristic person. In law, basically in law, a natural person are people like us now. Yeah, human is naturally. But now organizations, entities, companies, corporations, businesses are juristic persons because by law, a company can sue in its own capacity and can be sued. So meaning that the law actually recognizes company A as a person. So that means you can drag company A to court without even dragging the director of the company. Of course, at the end of the day, when matters like this come up, there's something we call lifting the veil, and then lifting the veil just means you are lifting the veil of the company or incorporation or entity to reveal those operating it. So basically, at the end of the day, when you drag the company to court, it's not as if you are bringing the building to court. Of course, the individuals, I mean, principal officers of the company that will represent the company in court as the present people in court, that kind of thing. So basically, I'm just trying to say, because we know that in most cases, even if the principal officers of the company die, I mean, even if all the principal officers of the company die, it is always easy to appoint new principal officers. So that means, regardless of how many principal officers die, the business doesn't necessarily have to die. That's what I'm trying to say. So it's always good to, okay, in you appointing executors, you can appoint maybe one natural person and one juristic person. So also a will allows you, okay, a will also allows you name guardians for your minor children. Just the same way you can give instructions for your burial arrangements and all of that. You can also give instructions to say, okay, just in case I pass on and become my children's property, I appoint my younger sister, her name is so, contact details so, given at so, to be the guardian for my children. Also, a will allows you to create a testamentary trust. In my next teaching on trust, I'm just trying my best to keep trust to the end because trust is actually wide, like I said. So, um, a will allows you to create a testamentary trust. Let me just briefly explain that. Or okay, let me just wait till the next one. Then I already have something on testamentary trust. Then a will can also be revoked during the testator's lifetime. You know, we mentioned a codicil earlier. We mentioned amending a will. So that means you can draft a will today and say that and appoint your wife and children as beneficiaries. And then next tomorrow you wake up and say, no, this my particular son has pissed me off. Or maybe this my particular son has even passed on, or this my particular spouse, maybe my father or my mother has passed on or something, and you want to change such beneficiaries, a will can be revoked even during your lifetime. So now this will take us to our next teaching, which is trusts. So now, a trust is a tripartite fiduciary relationship in which a settlor, as I've explained, a settlor is the person that creates a trust. Please don't let us mix up settlors and testators or testatrix. Testators and testatrix speak only to wills. Settlors speak to trust. And then the settlor gives trustees, like I said, a natural or juristic person who owns assets in trust. Now, I wrote a natural or juristic because there are situations where you can actually appoint an individual as your trustee. But in most cases, because you want to just be very sure that whoever I'm naming my trust, because at the end of the day, your trustee, as you can see, I said you're transferring the rights to manage. You're transferring ownership to the trustee. Imagine that me now, let's say my name is Chief Anuwakwa ABCSAN, for example, and I appoint, let's say I appoint my sister, for example, as my trustee. I know at the end of the day, yes, my sister is my sister, we're related by blood, but she's also human. She could wake up when I'm gone and decide that, okay, all this asset that my brother has been transferred to me before he passed on, I'm not even keeping it for his beneficiaries. I want to use it for my own personal debt. Do you understand? And there's nobody that will be able to hold her to say, but your brother said this. Of course, she'll tell you that she's the trustee and then she's doing what her brother said. And you'll be able to hold her to it. But imagine you appoint a juristic person meaning an actual entity as trustees. For example, in this case now, in this scenario now, Meristem Trustees Limited, for example, it is always safer and better because you have peace of mind in the sense that the juristic person is usually regulated. I hope you know that even when you incorporate an entity, no matter how small the entity or business is, the business or entity is regulated by CAC first of all, because you don't pay to register with CAC. So that means no matter what is happening, that business is put to check first of all by CAC. Then when it comes to specific duties or rules of all these entities that we incorporate, they also have their own regulators side by side that ensure that the roles of these entities, the roles of these people, for in this instance, trustees now, is being monitored and being checked and balanced. So, for example, for trustees now, our major and core regulator is SEC, that is the Securities and Exchange Commission, meaning that every step that a trustee takes is being monitored closely by the Securities and Exchange Commission. So I can rightfully say that if you have business or dealings with a trustee and the trustee is already erring in their duties, you can actually file an application or some sort of petition to SEC to say these trustees you don't think they are viable or credible or reliable. SEC will definitely look into it. Do you understand? So basically, a trust allows you as a settlor, give trustees the right to manage your assets for your beneficiaries. I also explain beneficiaries here. So a trust is usually governed through a legal document known as a trust deed. Now, A will is the document in its own instance already. But when you're talking about an estate plan called trust, the document that actually binds that whole arrangement, that whole structure, is a trust deed. A trust deed contains all the provisions and terms guiding the operations of the trust. Upon creation of the trust and its assets become distinct, held and owned by the trustees, hence separating legal ownership of the assets from the person. So remember earlier I said the trust is a tripartite fiduciary relationship. So basically, tripartite because it involves three parties, three major parties now. Three major parties meaning the individual who is the settlor, the trustees meaning a juristic person in this case, and the beneficiaries. So now there's a flow because you have three parties, meaning that you have the settlor who transfers legal ownership to the trustees to hold in trust for your beneficiaries. So it means that you transfer legal ownership to your trustees, and then maybe at the point in time where you say, okay, because a trust doesn't necessarily mean you need to be incapacitated or dead for it to work. So it just means you've transferred the trustees to hold in trust for the beneficiaries. I will explain because there are also types of beneficiaries when it comes to the trust. I will explain for that as we go on. So, first of all, you need to know that a trust allows you or makes you transfer legal ownership to the trustees. Assets held in trust are not accessible to claimants, creditors, or individuals except those acknowledged by the state law in the trust deed or those already encumbered prior to the trust. Let me explain why this is important. This is important because I know I'm sure you are familiar with cases or you've seen cases where a maybe an individual who owns a lot of maybe funds and all of that, owns a lot of estates, gets in some sort of trouble, and then maybe the person is in court, and for some reason they've gotten another party has got maybe an injunctive relief or something to say, okay, this your asset that you own in your name can no longer be accessed by you pending when this litigation is over. That only happens because legal ownership still resides in the hands of that individual. So now remember that I said a trust means you are transferring legal ownership to the trustee. Now, once that has happened, no matter what the situation is, even if you get to court, that property no longer belongs to you. So meaning that the court cannot say, oh, you no longer have access to this property. But in the actual sense, this property doesn't even belong to you. Property already belongs legally to the trustees who are already holding the trust for your beneficiaries. I hope that's clear. So now let's go to the types of trust. I've explained the basic background of the trust, and then I would say that a trust is usually unique in specifications, in the sense that the first trust I mentioned is an education trust. Just like I said, just like I explained, putting two plus two together, you'll be able to tell that, okay, this is a trust arrangement that speaks to the education of my beneficiaries. So basically, okay, let me just give you the types of beneficiaries before we go into these types. We have primary beneficiaries and secondary beneficiaries. So I'll explain why it's a primary beneficiary and secondary beneficiary at the time. So because a trust is an arrangement that even starts to work while you are alive as a secure. You don't need to pass on, you don't need to be incapacitated. You can set up a trust now, and as you are living your day-to-day life, your trust is also living its own day-to-day life. So it means that the trust is functioning as your life. So it also means that you as an individual being the settlor can even be imputed as the primary beneficiary because of course the funds in this trust, the assets in this trust are actually yours. The fact that you transfer the legal ownership to the trust, it doesn't mean if you call the trustees to say, oh, please, I need 5 million naira for something, the trustees will not give you. Because at the end of the day, it belongs to you. You are the one that put this structure in place. But of course, the trust deed is there, don't forget. The trust deed is already there guiding the operations of the trust. So of course, the trust deed will already say, okay, so person is the primary beneficiary, meaning that of course, if the primary beneficiary calls to say, oh, I need this, by default, you should, because we are holding a trust for the beneficiary. Now, the secondary beneficiaries can mean your children, your spouse, if you don't want to make your spouse the primary beneficiary, your siblings, your children, that uncle I mentioned, that that woman that sells fish on the street, that woman that sells bread on the street, that kind of thing. So those could be your secondary beneficiaries. So the education trust basically is one of the estate planning tools that we offer American trustees. And as you can see from my screen, it speaks to the education of the beneficiaries. So it just means you setting up a trust, setting aside funds that cater solely to the education expenses of the beneficiary upon the demise or incapacity of the said. These expenses can vary depending on the instructions given. I know, because I said education, you might just want to say, okay, since the education is said, that means it's only their school fees, their their school uniforms, their books that this trust can cater for. No, that's not the case. When it comes to education, of course, we know that all work and no play makes Jack. So definitely, you can even include that every holiday when my children are on holidays, or at every point in time my children are on holiday, I want my children to always go to Mr. Biggs every Friday up until school resumes. And I want the education for the people. You already know that, for example, your children need that Mr. Biggs playground, Mr. Biggs food, Mr. Biggs pastries to actually balance their education. Now, we're not saying the education trust will cater to you buying clothes for the children. No. Things that you know, okay, speaks almost directly to the education. Okay, they want to go for summer lessons. Of course, during the summer lessons, they need to get lunch, you need to get that. Your education trust can speak to that. It can even speak further to, okay, every other day when you are alive, you take your children to, you take them to Kigali, you take them to Nairobi, you take them to Maldives, you take them to the UK or something. Your education trust can also speak to that. Say, okay, I want a situation where every point in time with this my children are on holidays, they fly to go meet their uncle in the UK. The education trust can speak to that. Because like I said, it is almost directly linked to the education of these children. You already know that if my children don't go on these trips, by the time they come back the next session, they don't resume as good as I want them to resume. But anytime they go on this vacation or on these holidays, they resume and they resume refreshed, strengthened for the new session. So basically, that's what the education trust entails. One other thing to note is that in an education trust structure, it's not every kind of assets that can be put into an education trust. Now, a trust doesn't limit you on the kind of assets to put in, but the specific and uniqueness of your trust will determine the kind of assets that can be put in that trust. For example, an education trust, there's no point putting your house in an education trust. What is your house in an education trust? What is what is your other assets like that are not cash related, are not near cash during your education trust. So in most cases, you find out that in an education trust structure, it is usually investment, cash, near cash assets, shares, equities that are usually there. So that at least you are allowed for the continuous growing of funds in such trust to actually pay for the instructions or live to live to the expectations of your instructions at the point where you want it to come to life. So you just put assets like your cash, your net cash assets, so that if your children maybe get to secondary school and they start paying their fees, it is always easy to just, of course, if it's investments, wait for the ROI or maturity date or something, of course, pay their fees. And for example, in education trust, for Western trust, we make payments directly to the school. It's not as if because it's an education trust, the child can now call us myself, um, trustees, please, I need 1 million naira. We will ask you for what? Of course, we know you're a beneficiary, but if it is not in line with the instructions the settlor or the primary beneficiary has put in place, there's no point. Sorry for even mentioning primary because at the end of the day, as an adult, there's no really point calling yourself a primary beneficiary in an education trust. But yes, there's no point giving the secondary or the beneficiary to an education trust the 1 million naira, of course, since it doesn't speak to any of the instructions within the education trust. So in most cases, you just find out that beneficiaries reach out to us to say, okay, the session has ended. My new session is going to resume on the, for example, on the 19th of April. So this is the school details, this is the school account number, this is the name of the school. Please make such payment. So we trustees make payment directly to the school, and of course we share with you the receipts to tender to the school or something. In some cases where the beneficiaries cannot reach out to us themselves, probably because they are actual minors, the protectors come to play. Now, the protector is somebody similar to the executor, like I mentioned in the will. The protector is somebody you actually appoint to oversee the affairs of the trustees, ensuring that all of the instructions in your trust deed is what they are following. Now, I know a frequently asked question is, so that means the protector can make decisions on behalf of the trust. No, the answer is no, because your protector is only there to ensure, to monitor, to actually be there to know that, okay, the trustees are following the instructions of the settlor, meaning that the protectors cannot alter any of the instructions. The protector cannot change any of the instructions. In fact, the protectors in most cases are not even aware of the contents of the trust, or the trust deed, I mean. So it means that the protector only becomes very relevant at incapacitation or demise of the settlor. And when I mean relevant, I mean at that point, because American trustees, we make it a duty to always send quarterly reports to our settlers of various trusts that we handle. And of course, because the settlor passes on doesn't mean such reports will end. It only just means now that the settlor is incapacitated or passed on, the protector has come into a position where now the protector can receive these reports, can receive this valuation report, valuation statement about the trust. But the protector can never say, okay, I need this trust to end today. It is not their trust, it is not their business. All they have to do, the only job they have to do for a trust agreement is to ensure that, okay, the settlor has said that every 6 months, give my church 1 million naira. Every 1 month, give all my children equally 200,000 naira. And the trust has been doing that. So sometimes, though, for situations where the settlor has passed and all of that, and the beneficiary wants to make requests. For example, I know earlier I said a beneficiary can just call to say, oh, I need 1 million naira. If the 1 million naira the person has asked for doesn't speak directly to the education of the client or the education of the beneficiary, will not respond to such requests. So my mind is going to a particular client of us that is an education trust basically, but of course the state law has passed on, and then the three children, they are all boys. The first one usually makes requests on behalf of the other two. Now, anytime he wants to make requests, it doesn't mean when he calls us to say, oh, trustees, we're resuming a new session. Of course, if you want to resume a new session for Ian, that it sends us the school account details and the school's name for make payments. But of course, don't forget, an instruction could also include their allowances, purchase of books and all of that. And it's not all schools that will help you actually get books on behalf of students. So in cases like that, the beneficiary needs to actually make direct requests that go into their own accounts, maybe for books, for allowances and all of that. Of course, that's where the protector also plays major roles in that situation, because when a beneficiary calls say, oh, I need this amount of money for my books, or I need this amount of money for this project I'm about to embark on in school, maybe if I arrange project or something, I need to amount of money. As trustees, we have the duty to call the protector to ensure that the protector is aware and the protector agrees that such funds can be disbursed. So the protector actually plays a lot of roles, a lot of major and important roles, but the protector can never alter a trust. Also, the testamentary trust that was mentioned earlier when we were talking about it, A testamentary trust is a trust that is created from a will. So, for example, I mean that um, in maybe at the point of demise of the testator, maybe the testator already has a will in place. The testator will just put an instruction to say, "Oh, at my demise," for instance, maybe the children of the testator or the testatrix are still quite young, or you just want that the beneficiaries attain some sort of landmarks before such disbursement occur. A will will just say, okay, at my demise, all my investments, all the cash in my account, all of this, all of that, should be put in a trust that I want to set up with Maritime Trustees Limited. Meaning that this kind of trust now, I've been saying in the morning that a trust can actually coexist while you are living. You are alive and the trust is also living. But this is the only kind of trust that doesn't live side by side with you. Because this kind of trust only comes to life at your demise or at the demise of the testator. So it means that at the demise of the testator, the trust is now being created. So of course, in the instructions that would have been set out in the will, the protector would have been appointed, the beneficiaries would have been explicitly stated, all of that would have been stated so that in setting up the trust structure, it will be difficult ascertaining who the protectors are, who the beneficiaries are. So now this takes us to living trust. I did not write too much on that. I didn't write anything on that living trust, Islamic trust, special needs trust, and auto trust because from the way I've been explaining things, you understand that a trust is actually a particular kind of arrangement. But like I said earlier, the trust speaks or the type of trust depends on the uniqueness of your objectives. So it means that your objective is the education of your children. We call it education trust. The objectives of this trust you're about to set up is for the medication or the medical or the payment of medical bills for yourself, maybe in case of incapacitation or for your beneficiary. Maybe you have a son or a child that has autism, that has Parkinson or something. We call that special need trust. You set up a trust because of your assets that are not domicile or are not in the same location as where you reside. We call that offshore trust because that speaks to your trust that are abroad or overseas. But all of this still falls under the living trust. So this takes us to the Islamic trust as it speaks to Islamic trust just speaks to we call it the Waki. That's the name, that's the Arabic name, the Waki. Um, that just speaks to, you want to set up a charitable foundation or you have a reason why you want to just speak to just your Islamic needs. Now, why Islamic trust will also be very different is you should understand that Muslims, you don't usually do investments that are non-ethical. So basically, a lot or majority of Muslims, by their laws, are bound to involve themselves in ethical investments. And that's one thing you should also note about trust. When you put these assets in trust, when you transfer ownership of assets into trust, it doesn't mean those assets, for example, you transfer 1 million naira into trust. It doesn't mean when you maybe at your demise in 10 years, it is that 1 million naira that will be there for your children to start sharing or start dragging with. It means that once you put any form of assets into trust, income generating assets into trust, for example, those assets will continue to yield income. And we as trustees, this will also be guided by the trustee, but we as trustees also have the discretion to invest such funds, such investments, such monies that come from your investments, your cash, direct cash, your shares. We ensure that we invest them in credible instruments, incredible or viable instruments that ensure that the funds in the trust don't deplete to zero cover. Because of course there are a lot of things, a lot of maintenance that occurs from setting up a trust. And imagine that we're not growing that well for you, we're not growing that asset for you. It means that in a couple of years, your 1 million, and maybe when you pay annual trustee fees, or maybe 500,000 twice, the money has finished. But imagine that you put 1 million naira in your trust, and then you already have an arrangement with your trustees to say annually your annual trustee fees will be a percentage of the interest earned. So it just means you give us 1 million naira, it is in your trust. We invest such 1 million or such funds in credible instruments that will give good ROIs, which means that even at the end of the day, when the trustees want to charge you for their annual fees, they might not even need to charge your capital because, of course, the interest end is what we're going to charge because we already said a percentage of interest end. I'm not trying to say that the only way trustees can charge annual fees is just by a percentage of interest end. There are other ways of paying fees. It could be a particular figure. Remember I mentioned 500K earlier. Some people, there's some state laws that will tell you, oh, I don't want you to take any percentage of my interest. Let us agree on a particular figure. I have clients that pay even up to 10 million naira annually to maintain their trusts. And that's because that's the figure that has been agreed on between the settlor and the trustees. Some settlors will tell you, oh, they're not convenient with an agreed figure. Let's agree to a percentage of the interest earned. Some would even tell you, let's even agree to a percentage of my net asset value. That means at the end of the year, once you evaluate my whole assets with you, whatever it is, take 0.5% of it as your fees. So basically, the fees can also be, and they can also vary depending on the set law, the agreement between the set law and the trustees. So this takes me now to the living trust structure. Of course, I've spoken about the majority of the things on this screen, but like I said, a living trust structure now is a type of trust that allows you as a settlor to actually be a primary beneficiary, meaning that you as an individual now, you're already tired of the day-to-day running of or monitoring of your assets or your cash or your this investments. You can just put it under the trust to say, okay, of course, the trustees let them manage. Because like I said, the trustees are not just there to hold, the trustees are there to manage. The trustees are there to ensure that the trust funds don't deplete. The trustees are there to ensure that the trust grows further and further. So it means that the trustees have the right to ensure that they manage your trust, your assets, your estates, the way in which you would have even managed it, or even better. So a living trust structure allows you to become a primary beneficiary, meaning that you yourself can always call upon the trustees for to make requests. And of course, because we know you are the owners of these assets, we will not tell you no. I mean, why are we telling you no? This is your money and it's your investments. So basically, that's how the trust is being structured. I know I've been saying the trust is work and all of that, and that's because trusts are not only set up for estate planning, but of course, today our discussion is about estate planning. That's why you see me put living trust and estate planning. There are also different sectors of trust. So when it comes to trust, the private trust is the one that speaks to the estate plan. We have the public trust, we have the corporate trust. Those ones are the ones that involve in bonds, federal government bonds, and all of that. Speak to the debenture trust and all of that. Those are the ones that speak to the corporate side of trust. So we're not talking about that. You don't need to be bothered at that scale. I know I'm running out of time, but of course, everything on my screen is something I have mentioned. While you're alive, your trust is running side by side you and all of that. And of course, I mentioned who the settlor is, I mentioned who the trustee is, I mentioned the beneficiaries, and I also mentioned the protectors. So now let us go to the kind of assets and how they are transferred into trust. Now, when it comes to real estate could be land, could be buildings, and all of that, can also come into trust. But in most cases, one question I'll ask my client is, oh, is this estate, is this real estate, I mean, is this land, is this building income generating? If they're income generating, it's good to always put them in the trust so that at least you are sure that, okay, once the income they are generating comes, it goes settles into the trust, so the trustees can go for you. So the mode of actually transferring real estate into trust is through SPV. Remember, I told you we're going to talk more about SPVs. So basically, SPVs are tools that are used to essentially transfer assets like real estate into trust. Remember the way I told you SPVs work. They're majority shareholders, you make the trustee majority shareholders to hold these assets in trust. So meaning that at the end of the day, even when the settlor passes on or becomes capacitated, and that is the point maybe where we need to transfer these assets to the beneficiaries. Just by means of deed of gift, the trustees can now say, okay, since the settlor has already said this property is for this person, by a deed of gift, you can easily draft a deed of gift to say, okay, this property belongs to this person, this share belongs to this person, this belongs to this person. Same way the equities work. Equities, shares that can be traded on the stock exchange, we will just mirror such shares, such CSS statements to a trust account. I know we are familiar with for us to trade on for us to have shares, for us to trade shares on Nigerian stock exchange, we need to have a CSS account, we need to have a CHN account number. Right? Likewise, the trust. So when I say you're transferring assets, you're transferring legal ownership to the trust, it doesn't mean you're transferring it to the trustee personally. So when it comes to shares, for example, equities, for example, we would also create an account, I mean, a legit account with the CSCS. So that means the trust, let's say the trust, the name of the trust now is Pimpora Trust now. Pimpora Trust will also have its own CSCS account, CSCS number, and CHN number. Meaning that all the trust, all the shares and equities in your personal name, maybe my personal name as AAI Egusi now, will be transferred to Pimpora Trust, which already has its own CSS number, CHN number, meaning that even when you are trading on behalf of the trust, you are trading on behalf of the forum, not my individual person now. I hope you understand that. Same way for private companies, shares of private companies, it comes through ways of SPVs. I know you remember that when I was talking about SPVs, I kept mentioning shares. Of course, you want the shares that your family probably owns to remain in the family, and SPV works for you in that point. So cash, liquid investment, financial assets, that's very easy. You can easily decide, okay, you want to transfer it to the SPV to, or you just want to do a direct transfer. Maybe you have funds in your account, you have 1 billion in your account, and you want to just make sure the trustees are managing properly. You can transfer 900 million to the trust, so that the trust maintains the 900 million while you even have 100 million in your account personally. Then the trustees will help you grow on that. But you might also want to say, okay, you want to transfer the 900 million to the SPV created, it also speaks the same volume because of course you're still transferring the level ownership. Same thing with investment. You can include in your trust to say, oh, I have this investment going so so. So your asset managers will in turn in that point in time create accounts for the trust, sub accounts now for the trust to say, okay, this is Pimpora Trust in our asset management firm that owns this mutual fund, that owns this bond, that owns this treasury bill, that kind of thing. Same thing with banks. We don't just say transfer the money to our account. Because of course, if you transfer money to our account, we decide to use it. Of course, I know you have the SEC to report us to, but you know, you can't just determine how people are. But of course, because the trust, that's one of the instructions and regulations we have from SEC. It's an instruction that trustees must always keep separate accounts for every trust. Meaning that because Mr. A, Mr. B, Mr. C are all have trust, it doesn't mean they are going to the same account. They must have separate accounts. That is why the SEC does a lot of regulatory visits to a lot of all these trustees to ensure that, okay, let us even see your books. Let us be sure that, okay, before I trust has its own bank account, has its own CFS account, has its own SPV or whatever, and this other trust has this one has its own account. We always make sure that every trust has a separate and distinct account from the trustee's account. Now it is of course normal that American Trustees Limited will have its own bank account. But of course, not because you're transferring legal ownership doesn't mean you have to now transfer into our personal account. But of course, we would liaise with your bank, with your asset managers to ensure that bank accounts are opened in those banks, especially if you want us to continue banking with such banks, so that anytime you need to transfer funds to those accounts, you just transfer directly to the trust account after that time. Same thing with other assets, you can transfer through SPVs and all of that. The last one says, including drafting a will to accommodate some tangible assets. Like I said, not every kind of asset can actually go into a trust, because it's always necessary that the kind of assets that are going to a trust. Of course, your trust can cover all your assets. But if you want a situation where there's proper separation of power, separation of ownership, the kind of assets you move into a trust need to be calculated. For example, you have a car. Don't forget I said legal ownership. If you are legally transferring a car to a trust, it means that you cannot be using that car every day. That means the car will be probably parked in the office of the trustee or parked somewhere. Do you understand? So there are some kind of assets that they are not really necessarily important to be put in your trust. If you have a car, you can actually deploy more than one estate planning tool, for example. You have a living trust structure that is already working for your investment, your cash, your real estate, and whatever. You can also have a will by the side. You can also have a deed or gift by the side. So I'm trying to say all these estate planning tools can also coexist with each other. I'm trying to say I can have a living trust structure and also have a will. I can have a will and also have a deed of gift. I can have a living trust structure and also have a nominated funds structure, that kind of thing. So I'm just trying to say that different kind of assets classes will also determine the kind of estate planning tool you can. I hope we understand that. Okay, so let's go to the merits and the merits of the living trust structure. So, like I said earlier, a trust structure is highly customized to suit a settlor's unique circumstances. Like I said, you want to set up a trust because of the education of the children, education trust. You want to set up a trust because of your special needs or the special needs of your children, special needs trust. You want to set up a trust because of your assets or your properties abroad, offshore trust. You want to set up a trust because of this particular trust. There are a lot of other trustees that offer other kind of trust depending on the uniqueness of the settlor's circumstances. Also, a trust allows for seamless transfer of assets to beneficiaries. Seamless because you don't need to go through the probate court like a will now, for example. You don't need to go through the probate court to say, probate registry, my father has passed on, give us the grants of probate to distribute or dispose his assets. The trust doesn't have time or doesn't allow for such stress. A trust will just transfer such investment, such cash to your beneficiaries seamlessly. Settlor no longer the legal owner of the assets. While I put this, I don't know if you can see my screen clearly, but you see that I put this exact point as a merit and also a demerit. I put it as a merit, like it was the scenario I mentioned earlier. I said, for example, you're in court and then the court wants to probably put an injunction on your assets and all of that. Because you are no longer the legal owner of such assets, the court cannot say, oh, this particular asset in trust can no longer be accessed by you. Do you understand? So that is why it's a merit. And of course, a trust also allows assets to be protected from third party interference. Third party, even to your protectors that have been appointed, nobody can actually interfere with your plan. Do you understand me? Also, it avoids statutory costs of estate taxes. So once you move your assets into trust, you're no longer you're no longer subject to estate tax. You don't need to pay any 10% or whatever percent depending on the jurisdictions you are also. Also, the settlor has the opportunity to observe how the estate plan is panning out and can make adjustments. Remember, a living trust structure, you are alive, you are even the primary beneficiary because you are alive to also enjoy from the trust. You can see how everything has been. You can see how fast the beneficiary, the trustees respond to your request. You can see how the trustees divorce. You can see how the trustees are already managing. So if you need to make adjustments or corrections, it gives you the room to make that. Unlike a will where or a testamentary trust, for example, that you're already gone, you can't even see what the trustees are doing. You can't see how efficient the trustees are. A trust will allow you more, a living trust structure will allow you to observe and see that okay, your estate is properly managed. Also, it takes us to I didn't write that, but there's also a merit that goes hand in hand with living trust structures, which is confidentiality. I don't know if you heard when I said even your protectors might not know the details of your trust deed. That's how confidential a trust deed is. That's how confidential a trust deed is. Unlike a will, for example, where once it is read, everybody already knows that, oh, when this man was alive, he had 5 cars, and the 5 cars, he decided to give his baby mama. He didn't even give his wife any of the cars. He gave the 5 cars to his baby mama. He gave his outfit to his baby mama. He didn't even treat the family right. There's nothing like that with a trust because nobody has access to it. In fact, your beneficiaries, except they tell each other, because of course you might have more than one beneficiary. Maybe 3 of your children are beneficiary in your trust. Your children, except they discuss and say, oh, I usually receive a payment of 1 million naira from from the trustees. How much do you receive? And this one says, oh, I receive 2 million. Except that happens, beneficiaries might not even know the details of a trustee. That's how confidential a trustee is. Now, the demerits of a trust. The first demerit is the immediate cost of transferring these assets to the trustee. So, like a will where it is at the point of your demise where your executors want to get your grant of providence when they start paying estate taxes and all that. For a trust, for every transfer of assets, if it is cash, for example, as you're transferring the cash to the trustee, you already know that the bank will own their charges, those kind of costs. When you're transferring shares from your personal account to the trust account, of course, TSCS will also charge you some administrative fees. The stockbroking firm you use might charge some administrative fees for that transfer. Same thing with real estate. We already know that once you're transferring real estate from one person to another, you must go through the land registry. Of course, at that point, the land registry will also charge you their own administrative fees and governmental charges. Same thing goes for the next point, which is Settlor is no longer. Yes, Settlor is no longer the legal owner. A lot of people will tell you, so I should transfer the legal ownership of all these my properties to you. What if you run away? I get that question a lot. And it's always funny because we are regulated. We are a juristic person. Even if I leave Mary Central Trustees today, I cannot carry your car along with me. It means that you can it means that your assets are protected. But a lot of people always shy from trust agreements because they will say, I'm transferring legal ownership, that's very risky, that's very risky. But of course, at the end of the day, you see that it works for your good. And one of that demerits is limited knowledge. Not everybody knows how a trust works. So because of that, people tend to say, oh, I'm not interested in this trust, I'm not interested in this, I'm not interested in that. But of course, a trust, as I've explained, is very, very is very, very viable, it's very, very reliable. And a trust is actually one of also very, very efficient estate planning tool that we have in this current modern time. At this juncture, I would like to ask if there are any questions for me. I hope I've not been talking too fast and all of that. But please, yes, if you have any questions for me, I would like to take your questions now.
Thank you, sir. Please, you can type out your questions if you have any questions. Oh, okay. So somebody asked, what happens to a trust in case of divorce?
Okay, I would like to even get more clarity on that question, but a trust structure now doesn't mean you're coming to the trust with your partner directly. So when you're setting up a trust, you being the individual, you are the settlor. If you want to bring your spouse into a trust, you guys become co-settlors, and that means that you guys would own the trust. So of course, if there are any forms of maybe divorce or something, instructions that are given, and like I said, the living trust structure can be revocable. So of course, if you guys go your separate ways and you want to split the assets or split the estate, of course, you can come back to the trustees and say, okay, we need to redraft this trust deed. We need to start afresh or something. So it doesn't really affect you, except of course I tell you guys are co-settlers. But if you just want settlor, we actually have clients that couples now, husband and wife, and they have their separate trust. The husband has his own trust, the wife has her own trust. So it's very possible for the husband to have a separate trust from the wife. Because we know lots of couples that in their own rights, they actually have a lot of estates and they actually want to put an estate plan in place. So except you guys are co-settlers, divorce doesn't actually matter in a trust arrangement.
So in the So you're saying that in the case where they divorce and they have to share properties or anything, because they're no longer legal owners, right? It does not they will not get to separate, like share or lose their
Like I said,
assets.
that's what I said, of course, if the situation of divorce comes up and they are co-settlers, they can always come back to the trustees and say, okay, since we're about to get divorced or something, please, we need you to draft this trust deed to say this, to say that, to say that. If you get to the point where you already transferred some assets to the trustee, real estate or something, of course, the same way it was transferred to the trustees can transfer back to you guys. You guys decide what you want to do. Do you want to sell that property off and share the funds? Does one person want to keep the asset? Does one person want to keep the real estate? So of course, it just depends on the co-settlers as the case may be.
Thank you. Is there any other question? Okay. So in the absence of any further question, we really thank you for your time. Thank you for the enlightenment. God bless you, sir. And to all of our attendees, I hope you've been able to make informed decisions, or you'll be able to. So if you need to contact Mr. Anu Oyegusi to set up your estate planning, please, you did not drop your contact details.
Oh, okay. So I was thinking that you being the host, you will share my contacts with the community. So I think
Maybe I'll be what?
be able to share my contact with the community. Except
Okay.
in chat room or something.
Okay, it's fine. So if anybody needs his contact or wants to start business with Maritime Trustees or any other aspects of Maritime, you can send us a mail directly and we can connect you. We can send you their contacts and you can continue your business from there. So I hope we can wrap up now at this point. So thank you for your time. Happy Good Friday and happy Easter in advance. Have a lovely, lovely celebration.